depressing material from a lawyer's point of view. I read the part and I listened to him speaking about the part of third-party claims when apparently now the client can sue, or any client can sue. There doesn't have to be any privity of contract. If apparently some material is published and anybody relies on it, they can sue the lawyer. And I'm just thinking that when I finish this speech here today, that I'll immediately go and report the whole thing to errors and omissions, because someone may possibly rely on what I have to say, and if it's wrong, sue me later. My material, and I'm going to follow it fairly closely, starts at page 93, and I've enclosed in the material a list or an index of the material. Firstly, I put a copy of your insurance policy, the mandatory policy, American Home Assurance. I put in a copy of Guardian Insurance. That's a precedent copy of an excess coverage, and a comparison of excess coverage in a non-waiver agreement. Why did I do that? I went around my firm and I said, I took a poll and said, how many of the members of my firm know who's our carrier on mandatory? 90% of them didn't know. 100% of them couldn't even find the policy. So I decided I'd put a copy in here so that when you all go back to your offices and you can't even find the thing, it's in the back. I'm not going to talk to you today about when a lawyer is liable or when he is not. David Stockwood has covered that area. I am simply going to outline as generally as I can the mandatory insurance coverage that is provided by the American Home Policy. Most of you will have excess insurance coverage, and there are different carriers for the excess insurance coverage. Guardian is only one of them. And I might say while I'm at it, read your policies, because the excess coverage is not the same as the mandatory coverage. People get the idea that excess coverage simply picks up where the mandatory leaves off. If you've ever read both your excess and your mandatory, you'll see all different kinds of words in the policy. You may not even be covered by the mandatory cover, and you may be covered by the excess. So if you're ever in difficulty, the first thing you should do is read your policies to see what they say. All right, American Home covers you up to $500,000 per occurrence. Up to July 1982, that is when this new cover came into effect, you had $250,000. It's important, therefore, to see which insurer has you covered. Now, you pay, and I'm just talking generally now, you pay $5,000 on the first deductible. The Law Society itself insures for the next $95,000, and American Home picks the difference up from $100,000 to $500,000. Respecting the deductible, the old policies, you used to have to, for defense costs, put up the $5,000. Now, you only put up your $5,000 deductible if someone pays out. That is, if the insurer has to actually pay a claim. Otherwise, you get a free ride. Now, the mandatory cover policy, if you report, does not cover you for reporting for the excess. So I can advise you this: report to both your mandatory cover and your excess cover. When you report to the Law Society, they do not immediately report to the excess cover people because they don't know who they are. Now we get to the good part. If you look at page 94, this this new shift the law society's come up with. It's a sliding scale of levies and deductibles. And it starts when you had no claims in the past 5 years, it's $825, $3,500 deductible. Up to the worst, you made 4 claims in 5 years, $3,300. $10,000 deductible. The definition of when a claim is made is set out in the Law Society's notice to the profession, and a copy of it is in the material in the back. There's one problem in the NB section of the definition of claim made. It should say condition number 5. I've reprinted it as condition number 6. But I'm told that's wrong from the Law Society, should be 5. What it means is this: if you report a lot of claims, or if you have people reporting to the Law Society, and the Law Society investigates each of those claims, opens a file on it and investigates it, spends some time on it, then your levy's going to go up. What the NB means is that if you send in a notice saying, gee, I may have done something wrong, and nobody pays much mind to it because they don't think you've done anything wrong either, and puts it in what's called a John Doe file, then there's no tick made on the wall, so to speak, and your assessment doesn't go up. Which policy applies? That's a big question up at the Law Society right now, and I have set out 5 important dates for you to review when you look at your policies. When the occurrence takes place, that's when the error and omission occurred. When you became aware of the problem. When you gave notice to the insurance company. When a claim or suit is actually made, that is, when someone sues you. And when the policy period starts and ends. Now, you just look at the first page, American Home, the policy period started July 1, 1982. It's been extended now, so you're covered to July 1, 1984. It's a 2-year cover period. And you got to read the policy to understand which policy applies. If someone starts an action against you within this 2-year policy period, okay, then that policy applies. If in this policy period you became aware of a problem and you reported that problem, and let's say nobody sued you until 1985, it's still covered in this time frame. That's what's called a claims-made basis. Then they put in a kicker, and you should read the kicker. It's Section 2D, and that says the policy doesn't apply if, in our instance, before July 1, 1982, you knew of something and you didn't report it. Let's say they sued you right now. Within the policy cover period, they don't cover you. Then you got to scramble around and see if the other carriers will cover you. And of course, then everybody runs for the woods and says, it isn't me, it isn't me. And then you've got to go sue them. Now, that's probably the best reason for reporting as soon as you get the idea you may be in the glue in some situation. The catch-22 problem, of course, is obvious. You keep reporting these things, you zip right up to $3,300 per year, the top limit. If you don't report them, they may take a very dim view of that and deny liability altogether under the condition that you must report promptly. Now, the question, and an important question, is there coverage? And you should read the words of what coverage you have. It's an act or omission in the performance or intended performance of professional services for others. You can't be sending an opinion to yourself. In a capacity as a lawyer, and that's key, of the Law Society of Upper Canada. You can't be giving opinions if you're a member of the Alberta Bar or something else. You have to be in this jurisdiction as a lawyer and giving them to somebody else. Now, arising out of those two lines are just literally hundreds of cases, which I won't go into. Many cases have arisen on this matter of a lawyer acting as a trustee. So they specifically put in condition 4 and defined the ambit of the insurer's responsibility in a trust situation. And it's tricky, and you should read it. The words that are interesting, at least to me, are legally responsible in the usual solicitor-client relationship, which means to me that they're trying to cut down the odds for what David Stockwood was talking to you about third parties. Solicitor-client relationship appears to me to be restricting it to your own client. I don't know, no cases on it, but that's looks like where they're moving. I'm not going to go into David Stockwood's lecture except to say this, that I agree with his definition. Mine is probably as simplistic. Why did the client go to the lawyer in the first place? Well, if he went to him in the capacity as a lawyer, well, if the lawyer's negligent, we have to cover. The insurance has to cover. For example, if he went to him and the lawyer on his letterhead wrote a long opinion as to how to make an atomic bomb, I don't think that would be within the ambit of legal services. Things may be slow in the outlying districts, and maybe that's what you're doing these days, I don't know. And maybe Guardian thinks you may be doing that too, because if you look at their policy, there is a specific exclusion for making atomic bombs. If you look at page 128, you go around making them in your back office, whether it's after hours or not, and they're not going to cover you. Now, the next question is, was the act or omission negligent, or was it dishonest, fraudulent, criminal, or malicious? American Home doesn't cover for any of the latter acts. My perception of all these words simply means this, that if the lawyer does or omits to do an act with intention, then the policy doesn't cover. If he had no intention, that is, he didn't know that what he was doing or not doing was legally wrong, then he's covered. Now, that's just my own definition, and the courts may not follow that. What happens to the innocent partner of the fraudulent partner? Your partner's obviously stealing, and someone sues the partnership, and under the Partnerships Act, everybody's liable for everybody's acts. And the innocent partner says, well, I should be covered. Well, up until the American Home policy came along, the insurers were denying liability. It's specifically written into the policy now that innocent partners of fraudulent partners will be covered. But you got to look at the key words, because you can't be either the author of the dishonest act or an accomplice. Now, I've gone through all those words and looked at all the definitions. There have been no cases on it as yet, but I don't think that if you're sitting in the next office watching or listening to your partner steal, that anybody is going to cover the firm. if you hide behind the definition of accomplice or author in its strictest definition, I don't think the courts are going to go with you. I would think this too, that the insurer would deny liability because of late reporting, and the court would probably go along with them in the circumstances. On late reporting, cooperation, and disclosure, you should give notice as soon as you practically can. And you got to cooperate with the insurer as you go along. In the past, certain insurers have relied heavily on the late reporting. They've said, no, you didn't report for 5 or 6 months after you should or ought to have known there was a problem, and we're denying. In my opinion, if no prejudice is shown, that defense never runs. I've left for you Section 106 of the Insurance Act, which will, if nothing else, give you some comfort when you walk out of here today. And I really don't care how long it is, how late you are, as long as the insurer is not prejudiced. And if you want something that'll help, the page 105, Craig and Simcoe and Erie is a great case of late reporting where the court said, we don't really care how late it is, there wasn't any prejudice, and you got to pay. You've got to cooperate too, and this is important, in making settlement, conducting suits. You got to attend the hearings and the trial. You got to assist in giving evidence and getting the witnesses together, and you cannot make any deal on your own unless you want to pay for it yourself, and that's in the policy. You want to go make a deal on the side, you pay for it. The non-waiver agreement is a thing that's being used more and more frequently. If you have a problem, the insurer may come to you and say, look, we haven't investigated all of the facts. They're very complex. We want you to sign a non-waiver. Non-waiver simply means this, that neither the insurer or the insured waives any rights that it had under the policy while the insurer is defending you and investigating the whole process. Now, it's a benefit to the insurer because the insurer can deny liability anywhere along the line. In other words, get off the bus. It is of great benefit to the insured because the insured gets legal representation on a free basis from then on. If they didn't use the non-waiver agreement, you would have a lot of outright denials right at the first. So that if you're asked to look at and execute a non-waiver, think of the benefits to you in doing so. Settlement of claims. Many lawyers don't know what their rights are. Most lawyers don't. You get a lot of lawyers that say, I'm not going to settle that claim because I was dead right. My reputation is at stake if we settle and pay. They'll think I was negligent. Some lawyers say, we settle and pay, I got to put up my $5,000 deductible, so I'm not going to settle. American Home doesn't have to have you agree. They can settle without your consent. It's written in the policy. They may let you go on if you want to vindicate your position, but they only pay the amount that was offered in settlement. You say, fine, settlement offer of $20,000 comes in, we tell you to take it, you want to carry it from there, you're on your own. That's all we're going to do. On the other hand, what if the insured wants to settle and the insurer says, no, I want to fight it? The insured says, look, there's a settlement within policy limits, I want to take it and get out of here because he's suing me for 3 times the policy limits and I am liable personally if this plaintiff is successful. the insurer must take reasonable care at a minimum standard, and if he doesn't accept a reasonable offer within policy limits, he's liable for the whole bundle at the end. I've left you a case there. It's on page 105 as Dillon and Guardian just came in last week. Hasn't been reported yet. I won't talk to you about the excess policy. You can read it yourself, and there's also some material in the back from Marsh McClellan advising with respect to what point should be in the excess cover. In reading Mr. Stockwood's material this morning, he appears to have opened up with a line from Coleridge's The Ancient Mariner. I don't know much about poetry, but I remember that the Ancient Mariner got an albatross hung around his neck. And do you all remember why? Because he screwed up. And I guess what we're trying to tell you, both David and I today, if you don't want to wear it, don't screw up. Thanks.
Do we solicit questions? Do these things work? Are there any questions? Obviously just cover the field. I have to ask him questions about insurance.
Why won't you cover? Is this on? Yep. I'm wondering if, just for my own edification, could everybody put up their hands that have read the American Home Policy? That's, you see, about the same as my office. We have 4 hands up. How many people knew they were covered by American Home? About the same, about the same. Has anybody read their excess policy? Okay, okay.
Like to see people, if they're going to make mistakes, they're going to make them big.
I only say that because I was renewing my house policy of fire insurance last week, and that's what my agent asked me. Have you ever read the policy? I didn't put up my hand. Do you know who your carrier is? I haven't got a clue, I said. So he said, look, if you don't even know what's in your policy, you know, where do we go from there? And I said, well, look, I thought you were supposed to tell me. You know, I'm in good hands with Allstate. But that's one of the real difficulties that we see in the errors and omissions work, that the lawyer's never read the policy. The lawyer hasn't got a clue of what is in the policy, and has no conception of the difference between his mandatory coverage and the excess coverage. Because if you read just, for instance, Guardian covers you for libel and slander and just about anything. I mean, you can run right off and do just about whatever you want for Guardian, it looks like. But you can't in the mandatory coverage. So that if you read both policies and then you say to yourself, okay, what problem have I created? What error or omission have I created? Well, you go to both these people and say, well, gee, maybe I'm not covered by one, but I'm covered by the other one. Yes?
think if you look through the cases, that's the standard that judges apply. They go to, I haven't found a case where they have gone beyond negligence. But I agree that one of the problems is the perception of the public as to what they're getting and the perception of the lawyer as to what he's giving. I would agree with you that the public think they're getting title certification. I don't think that that's the system that we have here. My
One step further, if there's a gap between what the public thinks it's giving and the lawyers think, and the lawyer's perception of what he's selling, do we not think that, at least in the past number of years, the onus for the standard of care required of lawyers in the practice of real estate law would be felt to be by the judiciary, be more in line with the public thinks it's giving, rather than in line with what the lawyers think they're giving?
I think the historical position of judges has been that they're all former lawyers. So I think that is why you get a standard, the standard of what the lawyer is giving. I suppose the judge might say that there may be a general duty on the profession to publicize to the members of the public that what they're getting is not title certification, that what they're getting is only that their lawyer won't make a mistake. Now, I don't know, can you give me an example, because I am not familiar with real estate law, can you give me an example of a defect in title which would arise without any negligence on the part of the lawyer? And using negligence, that says meaning following the usual steps under our system? Yes.
Nevertheless, would have pretty severe financial impact. I once had to render an opinion on the Reservations Act, which we don't usually deal with much in the part of the city of Toronto. And I called with a friend of mine who practiced in a rural area, and I said, so when you search the title of a farm, you write to the assessment department to ask whether the municipality claims a lien on the Reservations Act. His answer was, well, I didn't used to, but recently I've taken to doing it. So that there's a thing that may or may not be proper practice in certain situations, or may not be, question of standard of care.
What about zoning? I think most of the real estate lawyers I've talked to would say whether you retain before or after the agreement of purchase and sale, zoning is your responsibility. Or does it depend on the nature of the transaction?
I would think in most real estate transactions you should find out whether it is in accordance with the contract or not. It's an issue that you decide whether you want to raise. But I think that you cannot ignore it. Virtually every situation.
I think the general point you raise is a troubling one, but it seems to me, as I read the cases, that the judges are still going on the old traditional standard of professional negligence.
Will you take the Haggerty case that you referred to this morning, which I think is the one that you referred to, of the undertaking to discharge the mortgage? That is a very schizophrenic case, but you explain it because by saying that the client has two causes of action, one in contract and one in tort.
No, that's not what I said. What I said was he has one action in contract, but there are two prongs to that action. The first is the general's duty of care, which happens to be the same as an action in tort. But the second, the judge said in that case, was the specific terms of his retainer. I think your comment that it's schizophrenic is a very good one. I think that lawyer must have been very surprised that the specific term of his retainer was that he was not to take an undertaking to discharge a mortgage.
I think everybody who's read the case knows it was quite surprised.
Yeah.
And the fact of the matter is the case, I believe, is under appeal. The Law Society has gone to a great deal of expense to prove that one's standard of care is a reasonable, normal practice, not the counsel of perfection. We may hear what the court realizes here.
Yeah, I guess the only thing we can say today is that even if that particular case, which I agree with you, I have some worries about it, even if that particular case is wrong, that we should be having in our minds a little mental checklist. Are we violating an express term of the retainer when we do something, even though we're not being negligent? I suppose that's just, and that may be a counsel of perfection, I don't know. Yes?
But I'd like to talk about the other issue that you raised, and that's the issue of liability of third parties who you or ought to rely on your opinion. Practical suggestion you have to a commercial lawyer to protect himself or to try and limit the liability in those circumstances.
Well, you know, in that standard reply to to an auditor's letter, you say this letter should not be quoted from or used with third parties without our approval. I see no reason why you shouldn't be using that type of phraseology in your letter. I suspect that you're not going to be able to contract out of liability to people who are within the direct duty. For example, if you're asked to deliver an opinion to a financial institution, then obviously your opinion will be worthless if it's qualified in that way. But I think what you're driving at is how do you protect yourself against all those people out there who might, on the third bounce, rely on my opinion? And I suppose the answer is you qualify your opinion and say, this is only intended for you. I don't know if anybody here does that as a standard practice in their opinion. I don't when I write an opinion. Certainly, when you give an opinion on point of law, I suppose you say, you have asked me to consider. My opinion is. You get a tenuous argument that in those circumstances, the you is the client. But I agree with you. Probably qualifying it is the best way.
Or you could put at the bottom, this letter will self-destruct before it falls into the hands of third parties.
Well, that's why really, I think that goes back to that fundamental question. What am I doing and who am I doing it for? I'm not sure that we always ask that. Yes? Well, I think that's the second thing, that if you want to limit your liability, if you look at the case in my paper, I've forgotten the name of it, where the common law spouse comes in, it's clear to me that the lawyers didn't think for a minute that they were acting for her. In this case, you run a risk that the court's going to find that you are acting for that shareholder, that he is your client. So I think your question really, the answer is, you say, go and get independent legal advice, and if you don't, I want you to know I'm not acting for you. Do not rely on me.
I find it a difficult response because you almost have to be saying that in the act for a lot of corporations. With every letter you send out, as a practical matter, I don't think you can do it.
Well, I think you're right, and that's what I said in the thing. The difficulty with all this is to try and protect yourself from these lawsuits without it's like defensive medicine, practicing defensive law. There are limits to what you can do and still function properly as a lawyer. I think you're probably right. From my point of view, acting for you after you get sued, I would wish that you'd written a letter saying, don't rely on me. But I suspect if you start writing letters like that, don't rely on me to everybody, you're soon going to be sitting alone in your office with nothing to do. So I think it's a good point. Okay, James? Thank you.
Everybody left before real estate instead of waiting to leave right before me. This afternoon, in our 3 sessions, we will look at specific areas of legal opinions in commercial transactions. Beginning in this session, with real estate transactions. Our speaker will be Donald Pierce. Don Pierce is a partner in the Goodman & Goodman law firm here in Toronto, and he specializes in commercial real estate transactions. I'm going to turn matters over to Don, and he will introduce the members of the panel who will be discussing the matter following his remarks. Don?
Thank you, Jim. If I maybe could start out by introducing the other members of the panel. We have Judith Oyen, or Judy Oyen as she likes to be known, who actually I've known more or less all of my life from Ottawa. She specializes as well in the real estate area with the Bell Baker firm in Ottawa. She was just recently elected a bencher of this law society, and looking forward, I think, to sitting in this panel as well. We have next Don Donahue, who practices with the McCarthy law firm and heads up their real estate section, which is a substantial section, as I'm sure most of you are aware. And on my left, we've got Paul Carroll, QC of the law firm of Smith Lyons in Toronto. Paul's practice is a little bit broader than just generally commercial real estate, in that he also includes corporate securities area, as well as the real estate development and financing area. So I think that you've got some people on the panel, excluding myself, if I might, that have a very wide breadth of experience in this area. When Jim first called me to provide this lecture, my initial thought was, what could I possibly talk about on delivering real estate opinions for a period of 20 minutes? I more or less looked on myself as a dirt lawyer whose job was to get the deal done by a particular time, and I'm sure most of you out there who practice real estate probably have that same point of view, that it's not for us to get caught up in the neat little academic points, but rather just to get the job done. When I started to think about it, I really decided that I was quite wrong in my initial view, that in fact, in every real estate transaction, we deal with a myriad of legal problems, and we solve them with, based on our experience and in the most practical, expeditious way that we can. And so that, as I started to develop the outline for this particular lecture, I discovered that in fact I had exactly the opposite problem, that the issues that had to be addressed, each one of which could probably be dealt with in a seminar like this, or at least in a couple of hours. And so accordingly, what I ended up with was in effect, a shotgun approach, just touching on many of the areas that I think that we real estate lawyers look at, or ought to look at, in commercial real estate transactions. I don't know whether you share this view, but I find that whenever I get involved in a transaction where real estate is but a component and there is a corporate aspect to it, I find a totally different world that exists. A straight real estate transaction is a relatively simple, straightforward one. It's got lots of problems, but I more or less know how to deal with them. In the corporate world, I find two transactions taking place. I see the clients dealing with one transaction, and I see the lawyers over here negotiating opinions in the other transaction. And oftentimes the negotiations on the lawyer's side is much more acrimonious than the ones on the client's side. In any event, it's obvious to everyone sitting here that the legal opinion in a real estate transaction is a very important document and clearly serves as a form of security, basically, or a blanket, if you will, for the client as far as tomorrow is concerned. What I am finding in my practice, and I expect you're finding the same sort of thing, is that there are a substantial number of opinions that are now being required that yesterday were not required. I'm finding that lenders' counsel, for example, are drafting very convoluted and complex documents, and they hand them to you, the borrower's solicitor, and they say, I'd like your opinion as to whether or not these are enforceable documents, etc. And there are many other aspects of a transaction that, again, today I'm finding the borrower's counsel, for example, are having to give opinions on that yesterday they never had to. It's one may decry sort of an inflow of American practice into the Canadian scene, and I'm not sure that's a fair definition, but on the other hand, it may be precisely what is happening. It's an unfortunate practice in my view, but having said that, I expect it's going to continue and increase rather than drop off. In any event, what I've decided to do as far as this lecture is concerned is really to canvass my recent history in some transactions and try and come up with some issues that I had to face in the delivering of opinions, and to try and develop, if I can, the reasoning that went into the opinions that were given in that particular transaction. As I said, any one of these topics we could spend 2 hours on, and clearly that's not the purpose of this particular lecture. At the outset, I think that there clearly are some preliminary matters that ought to be looked at by every real estate lawyer in Ontario in commercial transactions. The first one is you're often acting for non-resident purchasers, and the whole question of FIRA must clearly be dealt with right at the outset to see whether or not you've got a problem transaction or not. And I have no intention whatever of dealing with that topic. Jim Spence will be dealing with it, and he's got tremendous background and history of that. I simply want to raise it with you as a preliminary matter that should be looked at in every case where there is the possibility of a non-eligible person lurking in the background. Similarly, we've got the Income Tax Act that in almost every commercial real estate transaction will impact in some way or another. Indeed, I think you'll find in many cases transactions are structured solely to fall within one particular section or another of the Income Tax Act. And so clearly, in any commercial real estate transaction, one should start out at a very preliminary stage by talking to the tax experts to see whether or not the way you've got the transaction structured is the right way for the proper tax result, or indeed whether it should be restructured in order to fall within the appropriate income tax requirements. Similarly, when the tax people are describing what the transaction ought to be, you will have to work together in order to set up a structure to fall within the same tax sections. Now, David Stockwood addressed this morning the question of to whom do you address the opinion, and although he indicated that I was going to deal with it this afternoon, quite frankly, I think he dealt with it quite adequately this morning, and I think that if anyone heard the answer that I gave to his question, it's my view that, and again, I'm not trying to get locked up in a neat academic point, it's my view that if you provide an opinion in a commercial real estate transaction where you knew or ought to have known that someone other than your client is going to be relying on that opinion, and in most real estate transactions, by the way, it's readily apparent who those people will be. Obviously, you can come up with fact situations where that is not true, but I think in most cases that is true. And my practical solution to that was the one that I mentioned this morning, is not David's approach, which I think is a very good approach, his approach was where you would try and limit your exposure through some exculpatory or limiting language in the opinion. My approach is a little bit different. I would try and identify who those other persons or individuals or corporations might be and deal with it up front. Overcome the problems of conflicts if you can, and deliver your opinions to those individuals directly, of course with the appropriate compensation being delivered back to you, the giving lawyer. Now again, there was discussion this morning and a question that arose as a result of that conversation as to the use of the word certify as opposed to the use of the word opinion. It's my view that there is a connotation of insurance in the word certification, although there is no case around that says that. That is just a visceral reaction of mine to the use of that word. And it is also my opinion that the proper word in a professional sense, when you are requested to deliver an opinion, is to use that word, that in our opinion, or it is our opinion that, rather than the use of the word certified. The question that was raised, and maybe you'll re-ask the question at the end of this panel. Pardon? is one. There is no doubt that there's a rising tide of consumerism in this province, and you've seen it in many statutes, most recently the amendments to the Condominium Act, for example, and there's another one on the books now that the name of which escapes me. I just read it late last week, that is simply incredible. But it is obvious that there is this rising tide of consumerism that may very well prove to be difficult for lawyers in the future. It is not my opinion that the courts have gotten that far at the moment, and that the element of insurance, that we have not yet got to that point. Indeed, if I might add something that wasn't talked about this morning, the Americans, of course, have a concept of title insurance that is meant to deal with the very area that was addressed, I think, this morning. There is no doubt that there are areas that lawyers can leave out of title opinions and not be negligent for leaving out those areas. But there's also no doubt that they may be of some significance to your client. And the way he can overcome that in the United States primarily is through the use of title insurance. There are title insurers in Canada, two of them that I'm aware of. They have written, I think, an aggregate of about $90,000 worth of business over the last 5 years, so they clearly are not a very active business in Ontario in particular. But having said that, it is available. I think that with the advent of many more American or multinational corporations in Ontario, that you may see some requirements that will ultimately use title insurance more tomorrow than it has in the past. And that may be a partial answer to you. At your shaking your head, you don't think so. In any event, there are, again, as you'll note, I'm going to try a shotgun approach here on many issues, some of which may appear to be somewhat unrelated. But I hope that you'll bear with me, because I really couldn't think of another way of doing this that might make some sense. There are, in many cases, it's very clear at the outset of a transaction that an opinion will have to be provided before a transaction can be completed. And in many cases, it's clear that those opinions may very well be contentious. Again, it is my suggestion that you should try and settle the terms of those opinions as early in the transaction as possible. I recognize that that's not always possible, but I suggest that wherever you can, that you try and do so. Indeed, if you can do it, I suggest that you negotiate those opinions and attach them as a schedule to the agreement. Again, David alluded this morning to the problem of acting for more than one party in a transaction. This obviously is a matter of conflict that has been dealt with by the Law Society rules, but I don't think anyone really has focused on the problem of the delivery of opinions to your various clients that you're acting for. Clearly, the delivery of an opinion to a dominant party in a transaction may very well be not in the interests of another party to that transaction. I simply raise it as another danger that one must deal with when you're forced into the situation of acting for both parties to a transaction, or several parties to a transaction, that you must look at the question of opinions at the outset to see where down the road you may get yourself into a problem that you can't get out of. Obviously, your duty is to treat both clients, or all clients that you're acting for, as fairly as possible in the delivery of the opinions. Again, in commercial real estate transactions, it is not at all uncommon to cross borders, either in a lending transaction or in dealing with multiple properties across Canada or elsewhere. And the whole issue of how do you deal with the foreign law problems and the securities that one must obtain in those jurisdictions is a relatively complex area. I don't think there's any doubt that you must use a foreign counsel in each jurisdiction for his advice, both on the preparation of the documents in question and also dealing with the title matters and other related real estate or other parts of the transaction. I think the issue is not whether you do that or not. I think you simply must do that in order to protect yourself. I think the issue then is, what do you do with it once you get it? And clearly there's a gradation of comments that you can put into your own opinions or reporting letters, whichever language it is that we're using today. The principal lawyer may not even refer to the opinion of the foreign counsel. He simply may put the opinion in his file and pull it out if he's ever called on his opinion at any time in the future. He may refer to his opinion, but not rely on the opinion in the express language in the principal lawyer's opinion. He may also say that I've got the foreign opinion and I'm basing my opinion on that foreign opinion. Or he may say, I'm not giving you any opinion on that particular aspect of the transaction. Here's the opinion of the foreign lawyer with respect to it. I don't have any strong preference, quite frankly. I simply, again, draw the gradation to your attention. And indeed, if that generates a question, I'd be more than pleased to have the panel answer it. Again, when you're dealing with foreign counsel, sometimes they're not advised as to the nature of the transaction, the entire transaction, and really the amount of the exposure that they might be called upon. And I think that that's fair and reasonable that they be advised of that as early in the transaction as possible. Again, I think that you've got to look at the issue of conflict of foreign counsel as well, that it is possible that they may act directly or indirectly for one party or another to a transaction, and you should deal with that as early in the transaction as possible. And as I've got noted in my paper, I would suggest where there's ever any question of that you try and deal with it expressly in your agreement and have all the parties to the agreement agree that one foreign counsel or another should or should not be used in the delivering of those foreign opinions. Again, there are some typical matters that do require opinions in a commercial real estate transaction. Firstly, as you're all aware, there are recent changes that came in, I think in August the 1st, in Ontario and the OBCA that change rather dramatically the requirements or the powers of an Ontario corporation. And Judy will be dealing with that later in the panel, so I don't intend to go into it in any great detail at this point in time, other than to indicate that there are some changes, particularly in lending transactions, for example, where the requirements that you ask for before August the 1st ought to be changed dramatically, or at least changed after August the 1st. Similarly, the question of title is another matter that obviously your client is expecting you to opine on. It is obviously the cornerstone requirement of any reporting letter or opinion that you're delivering in a commercial real estate transaction. I could go on for days, and anyone who practices in this area could go on for days about the various matters of title that might arise. That is not, as I understand it, the purpose of this kind of seminar. However, I think that there are 3 or 4 areas of significance that we ought to touch upon in this whole title area. Firstly, we were just talking about this at lunch because it's indeed, if this in doing of this paper has done anything for me, it has focused my mind in on this problem, a practice that I had gotten into that I am now convinced is probably an incorrect practice, and that relates to the Land Titles Act. It has been my practice, and I think it's been a practice of many real estate lawyers in Ontario, that when he is doing a transaction or giving an opinion in respect of a property in Ontario under the land title system, that he will say that my title opinion is subject to the usual qualifications and exceptions under the Land Titles Act. Well, Don is going to deal with that later, and I think that you'll see that the tremendous exceptions under the Land Titles Act are such that you can drive a truck through that opinion, and I think that unless you've advised your client up front as to what those exceptions are, it's unlikely that that exception is going to help you if you run into a problem in that regard. But again, Don will develop that later on. Similarly, there is the remote problem of reservations in Crown patents. This is not likely going to give anyone in downtown Toronto or any other built-up area a problem. It can, however, be a problem as far as rural properties are concerned. And I might also just draw to your attention for any of you who might be doing any developments in harbor areas, federal harbor areas, that there is a potential problem there that one should deal with as early in the transaction as possible. You may be aware of the recent notoriety of this issue between the Toronto Islanders and the Toronto people. Now, I guess the most important exception that one must always look at when providing a real estate opinion is the Planning Act. I think that you're all aware, and I don't know what the exact percentage is today, but a substantial percentage of the claims made under the insurance program of the Law Society of Upper Canada is in respect of problems that emanate under the Planning Act. And all I want to do is simply say that and indicate to you that whenever you're providing an opinion in commercial any real estate transaction, you must look to the Planning Act and how your particular transaction may be affected by or contravene the Planning Act. Obviously, continues to plague practitioners in Ontario. And the last point on title that I really want to talk about is the new Construction Lien Act. It's created a whole new series of problems for practitioners in Ontario, and there have been many seminars on it, and I assume that there will be many more seminars on it. The clients, the lenders in particular, really, I think most of the major ones have probably got a pretty good handle on the problems that they might have under the new act. Some of the minor ones still don't, and they're still looking to the lawyers to provide them their guarantee that everything is just fine. And you can squirm and you can wriggle and you can do what I do in providing preliminary opinions, in my preliminary opinion, how they may very well lose their priority if their mortgage is classified in certain ways as defined under the Construction Lien Act. But I got to tell you, a lot of lenders are having difficulty with that kind of exception. I understand from Judy that, is it the benchers or is it the Law Society that's looking at a possible series of instructions, if you will, to the law profession as to what steps they should take to try and limit their exposure for negligence in this area. But again, it's a matter that whenever you're dealing with any construction going on with respect to any commercial real estate transaction, that you must look at with great particularity and try and protect yourself and your client in the giving of your opinion. Now, although it is not a matter of title, it obviously, zoning is an extremely important matter to your client. And when I talk about zoning, I'm referring to all of those other statutes as well, the Parkway Belt and the Escarpment Acts, etc., that plague practitioners in the Golden Horseshoe area. Clearly, it's an area that you must deal with in the providing of an opinion to your client. It's an area that is fraught with danger because it typically, I think, what a lot of lawyers will do is they'll get the best survey that they can get, and oftentimes the question as to whether it's an up-to-date survey is a separate question. They'll then deliver that survey to the appropriate official at the municipality and ask for that municipal official to do an analysis and to send back a reply. Well, the quality of the replies that you get varies tremendously. In some cases, they're incomprehensible. In other cases, they simply say the lands are subject to zoning bylaw 248/79. Here's a copy. And in other cases, they go on and they actually try and help you and tell you that it complies or it doesn't comply, and they got a group of boxes or something that they check off. I think that here you run into a very serious potential problem of what do you do if it is an incomprehensible answer? What do you do if the employee of the municipality makes a mistake? I think that everyone here who practices in this area probably is aware that there are a group of conflicting cases here. There's a recent case, as I understand it, where the City of Toronto were held liable for the negligence of one of its employees in this area. But on the other hand, there is more than one case saying exactly the opposite, that the municipal officials are not liable for the negligence of their employees. Again, in most major commercial real estate transactions, what I have tried to do, and we're very fortunate in our firm to have the luxury of planners on staff, and I recognize that that may be a bit unusual, is I try and have an expert involved. In our case, I will have our own planners do it. In other cases, I will insist that the client retain an architect or an engineer or a planner or whatever to try and have the appropriate analysis made of the zoning bylaws, the amendments to the zoning bylaws, any interpretations or cases that may have been previously heard with respect to those bylaws. And that also involves the question of an up-to-date survey, I might add, that I dropped off a moment ago. That is a whole other area that books could be written on as to what constitutes an up-to-date survey and whether or not you ought to have one in every transaction. Clearly, the answer is yes, if you can get one, you're obviously better off to have one. Most clients, or not most, but many clients are reticent to get one simply because it costs too much money. Now, I see I'm over my time already, James. I don't know. Pardon? Keep going? All right. As I said, if you're not going to get an up-to-date survey, clearly it is a matter that must be agreed to by your client. You must get express instructions, and it's my view that you should confirm that in writing, and any final opinion you should clearly indicate that your opinion is subject to any defects that an up-to-date survey might otherwise disclose. I won't deal with insurance. It's one of the most baffling areas to me in any event. If you can read what I've got there, it won't help you too much other than to just trigger in your mind again a problem that you must look at in the delivering of opinions. When you're dealing in a commercial real estate transaction, invariably you're dealing with chattels in addition to the land. You're all aware, of course, that there is no registration system for chattels, and therefore you must clearly provide the appropriate exculpatory provision